The commission focuses on communities who have been negatively impacted by policing and who are often not represented at the table for policy and decision-making, such as Black, Indigenous, immigrant, refugee, youth, LGBTQ, and houseless communities. The commission is charged with hosting community meetings like this, where the Seattle Police Department and Department of Justice and other partners are invited to present updates to the community and our other stakeholders. For this meeting, we look forward to information from our stakeholders who will be speaking tonight, as Felicia mentioned previously. At our April meeting, we hope community will continue to engage with us in this process and attend with any questions, comments, or concerns and provide feedback. We are extremely grateful for your time, energy, and emotional labor you have invested in this process. Before we start this meeting, I want to also take a moment to acknowledge the officer-involved shooting in downtown this past weekend. We will be working with the Office of Police Accountability and the Office of the Inspector General to assess the event and review policy. Any event where a life is taken is a tragedy. It takes someone away from their families and community, and the commission takes officer-involved shootings seriously and will continue creating and honoring space for community voices to shape police accountability. Thank you, everybody, for joining. We're going to have Matt Waldrop up from the Department of Justice, who's going to present first. And Matt, if you're ready to go and if you need anything from us behind the scenes, please let us know.
Will do. Thank you so much, Executive Director Grant. Thank you, Felicia Cross and the CPC for organizing this. Also want to thank the community for coming out tonight. I know everyone's time is valuable, so we appreciate the attendance. My name is Matt Waldrop. I'm an Assistant United States Attorney here in Seattle, Washington. I also have my colleague, Jeff Murray, who is a trial attorney with the Civil Rights Division in Washington, D.C. And tonight we're just going to talk about use of force as a concept and how that concept, use of force, applies to the consent decree and the work that we've been doing under that. And so to better explain that to the community, I've got a PowerPoint that I want to share, and we'll go through that and we'll just take it from there. So give me just a second to share my screen. All right, can everyone see that PowerPoint?
Yes, we could see it, Matt.
Great. Okay, perfect. So I think it's sort of important to start, especially with a concept like use of force, with sort of basic, first principles. And so, I think the typical question that we always get asked is, what is use of force and what does that mean? Well, the consent decree defines use of force as any physical coercion used by an officer in the performance of his or her official duties. And sort of unpacking what that means as a legal concept, an issue arises when uses of force become excessive. And what that means and what the Supreme Court has focused on when looking at excessive uses of force is whether that use of force was reasonable under the Fourth Amendment. That's sort of the analysis that courts and that we at the DOJ do to determine whether individual uses of force are reasonable or unreasonable and therefore excessive. And that inquiry, like most legal tests, is a balancing test. And it looks at the nature and the quality of the intrusion into that individual's Fourth Amendment right against the government's interest at stake. So it's a balancing test that the court will apply to determine whether a use of force is excessive. It's analyzed through an objective standard. And what that means is the court is looking to see whether the interaction, the use of force, whether it was reasonable under the circumstances and the facts that were present at that time. Now, we talk about individual uses of force and whether those are excessive or not, but what the department does and what we've done here in Seattle is we've looked at patterns and practices of excessive force. And the statute that allows us to do that is 34 USC 12601. And this is a statute that permits the department to investigate, like I said, patterns and practices of excessive force by government actors. Now, for individual incidents of use of force that are excessive, those are typically examined through private lawsuits brought either under Section 1983 or as Bivens actions. And so those look at individual incidents of excessive use of force. What we did here in Seattle and what we do in our other patterns and practice cases is look at, sort of a systematic look at a department, at government actors, and examine those patterns and practices. And so that's sort of what use of force is, how it's defined in the consent decree. But I think it's important to understand what that means in practice. And so I want to talk about the use of force and how it's referenced in the consent decree and the obligations that are imposed on the parties and all of that. So as many of you probably know, the consent decree was jointly entered into by the Department of Justice and the City of Seattle back in 2012. And that was following an investigation by the department into, like I said, allegations of patterns and practices of excessive force by the Seattle Police Department. Now, the consent decree explicitly addresses use of force in the following three ways. The first thing the consent decree does, it defines what use of force is. And that's important because the next thing the consent decree does is it categorizes uses of force. And the third thing it does, it establishes how uses of force are supposed to be reported, investigated, and reviewed by the department. Now, looking at the definitional section of use of force in the consent decree, it defines several concepts which are going to be relevant to the categories and then what's required under reporting, investigating, and reviewing those uses of force. And some of the definitions that are appropriate to sort of understand what we're talking about when we look at the consent decree and use of force is, like we talked about, just the definitional meaning of what use of force is. And within that, the consent decree also defines what is reasonable force. And that's force that complies with that Fourth Amendment requirement that I was talking about of objective reasonableness. Was the officer's actions reasonable in light of the facts and circumstances that were present at the time? The consent decree also defines important concepts such as injury, substantial bodily harm, and great bodily harm. And those are important later when we talk about the categories of use of force. And the reason that's important is the consent decree establishes 4 categories regarding the use of force. Now, these categories are based on several factors. These include the degree of injury caused, the potential of the technique or weapon to cause injury, degree of pain experienced, complaint by the subject, degree of restraint, duration, and physical vulnerability. And so taking those factors, the consent decree breaks out use of force into 4 categories. The first one is de minimis force. And those are physical interactions that are meant to separate, guide, and or control without the use of a technique that is reasonably likely to cause pain or injury. Now, examples of de minimis force under the consent decree are an officer using his or her hands to stop, push back, separate, or escort. And de minimis force also includes any discomfort or minor transient pain that's caused by wearing handcuffs after they've been applied. So this is a very low level use of force that we're talking about with this first category, de minimis force. And the second category of force is type 1. Now, this is force that causes transitory pain or a complaint of transitory pain. Now, examples in this category include disorientation techniques, wrist locks, and soft takedowns. Now, if an officer points a firearm at a person, that is considered a type 1 use of force. The third category is type 2, and that's force that causes or is reasonably expected to cause physical injury greater than transitory pain, but less than great or substantial harm, which were those definitions that we talked about a little earlier. Now, examples of type 2 use of force are the use of impact weapons, deployment of a canine that results in an injury, or a complaint of injury. The final category of use of force is a type 3 use of force. Now, this is force that causes or is reasonably expected to cause great bodily harm, substantial bodily harm, loss of consciousness, or death. Examples of type 3 uses of force are the use of lethal force, or the use of an impact weapon that strikes the head. And so the consent decree first takes uses of force and it defines them, then it places them into categories. And the reason the categories are important is because the consent decree requires specific reporting, investigation, and review depending on what type of force is used by the officer. Now, the goal of the consent decree is to focus resources on the most serious uses of force, while also requiring that all reportable uses of force are reported and not underclassified. So anything above de minimis use of force is required to be reported under the consent decree. You have an initial reporting, which looks at the documentation of the use of force, and that's supposed to immediately follow the incident, and that's done by the officer. Then there's an investigation and a supervisory assessment that follows. And then for type 2 and type 3 uses of force, the consent decree establishes a process that requires a critical review and examination of those incidents to assess their appropriateness and to identify any shortcomings in SPD's policies, procedures, training, tactical performance, and/or supervisory actions. So for the higher uses of force, there is a more robust review process that's meant to inform SPD policy and training going forward based on a review of those type 2 and type 3 uses of force. And again, the goal of the consent decree in requiring that deeper look into type 2 and type 3 is to have SPD look critically at those uses of force and to build on and hopefully have lessons learned from a review of those type 2 and type 3 uses of force. Now, in addition to defining and classifying uses of force and imposing certain reporting, review, and investigative requirements, the consent decree also has commitments that were made by the city regarding the concept that we've been talking about, use of force. Within the consent decree, Seattle's committed to maintaining a highly trained and knowledgeable police force and to educate the public on appropriate uses of force by its officers. There's a focus on de-escalation techniques when appropriate and feasible. There's also a requirement that de-escalation of the use of force occur as resistance from the subject decreases. So as a subject resists less and less, the SPD is supposed to de-escalate the use of force consistent with that. And then SPD is supposed to establish policies concerning when and where to use force under the terms of the consent decree. The focus of the consent decree is on uses of force and to have an accurate and proper reporting of those type 1, type 2, and type 3 uses of force. And we also want to have good documentation and investigation regarding those types of force. The consent decree also requires SPD to analyze its force data to determine significant trends, to identify and correct any deficiencies that it's seeing in its data, and to document its findings in an annual public report on its use of force. SPD, under the terms of the consent decree, has provided these annual reports to both the court and to the public on its website. Now, finally, the consent decree also required the parties, along with the monitor, to revise and look at SPD's use of force policies, its training, and its tactics to bring those all within compliance with the terms of the consent decree. Revisions to these materials have been reviewed and approved by the court on several occasions since the entry of the consent decree. SPD's use of force policies can be found in Title 8 of the department's manual. There's a link to it. It's got a definitional section. It tells you about investigating, reporting, and reviewing those types of force. Now, under SPD's use of force policy, its officers may only use that force that is objectively reasonable, which is what we talked about with the Fourth Amendment. But that use of force must also be necessary and proportional to effectively bring an incident or person under control while protecting the life and safety of all persons. So SPD's policy is a little bit different and does go beyond that objective reasonableness standard that we talked about that the Supreme Court established back in the 1980s. So finally, what has SPD done to show compliance with the consent decree's use of force requirements? Well, those have been measured through assessments that the department and the city have done over the previous 10 years of the consent decree. Now, in phase 1 of the consent decree, the original monitor found that SPD officers were using only force that was necessary under the circumstances more than 99% of the time. In phase 2, the city, through validation of the monitor and the Department of Justice, again found that its uses of force were reasonable, necessary, and proportional, and otherwise in compliance with the department's use of force policies. And that takes us to what these assessments established. And they established that the city first had full and effective compliance regarding the use of force requirements under the consent decree, and those requirements were sustained following a review in 2019. And now in phase 3, the monitor, along with the department, is again assessing whether SPD has sustained compliance regarding use of force, regarding reporting of use of force, and investigation of use of force. And that also includes a component regarding crowd management policies resulting from the 2020 protests. So that's what we're looking at right now, and that's what will be presented and talked about next month at the CPC's community engagement meeting, is that phase 3 analysis that we're doing right now. So prior to entry of the consent decree, from January of 2009 to April of 2011, SPD reported approximately 1,200 incidents involving a serious use of force. Now that means type 2 or type 3 uses of force, which are the more serious categories that we talked about from the 4 earlier. So prior to the consent decree, SPD reported approximately 1,200 uses of force involving serious use of force over about a 2-year period. During phase 1, from July of 2014 through October of 2016, SPD reported approximately 487 incidents involving a serious use of force. Again, that type 2 or type 3 use of force. And finally, during phase 2, again, from January 2017 through April of 2019, SPD reported 454 incidents involving a serious use of force. And so, that's just a real brief primer sort of on use of force and how that concept overlays what we're doing under the consent decree, what's been done and what is continued to be done by both the department and the monitor. So I just, again, want to provide my contact information. I am here in Seattle at the U.S. Attorney's Office and can be reached either by email, by phone, or by mail, whatever folks are comfortable with. But that is just sort of a brief overview of use of force and how it applies here with the consent decree that we've all been working on. So that's what I've got, Felicia.
Okay, Matt, thank you very much. We'll leave that up there for a moment. Is Brian, I can't tell. Is Brian on the call?
I'm on.
Brian, you're up next.
Okay, and thank you to the CPC for having me along with Mr. Waldrop here. What has been made clear through the presentation of Mr. Waldrop is that there's going to be significant overlap in what I speak about and what he spoke about, because what I want to try to do is talk in a little more detail about our policies and how the policies govern the use of force, the reporting of force, and the review of force within the SPD systems, and just get a little more granular on that. The use of force policy that was mandated out of the consent decree was developed in 2014. It was developed in collaboration with the Department of Justice, with the monitoring team, and to some degree with other city partners. The CPC certainly was involved in the development of the policy, although I will not say that at that time the engagement with the CPC was as holistic as it could have been. It was an odd time in the consent decree when the Seattle Police Department and the CPC were engaging regularly on the use of force policies, but not as much with the other partners in the development. As such, the Seattle Police Department was able to take many of the CPC's recommendations and incorporate them. And back in the day, I recall many hours sitting in a room talking with CPC leadership about what the policy should be, looking at some nuances and trying to better craft these policies. Nationally, our use of force policy is somewhat legendary because the initial inception of it was 90 pages of instructions to officers. It was comprehensive, it was detailed, and it did get very, very specific on what an officer should do and what officers should not do. And at the same time, it was because of the volume of information, it took a lot of time to train on, and we had to develop robust scenario-based training to guide officers, not just in terms of the theoretical application of this, but walk them through scenarios so that they could actually apply the policy in real time in circumstances where we could test and help guide them in their uses of force. One of the policy that was drafted, and I've already seen this in the comments, definitely does not skate along the constitutional floor. It was really designed to lift up above the Graham v. Connor standard and set a standard such that when officers made mistakes in the performance, when they didn't follow the policy, that did not necessarily mean that they were violating the Constitution. We wanted to give that room between, the legal liability that an officer individually faces in Section 1983 claims and the type of guidance that the department wanted to give to its officers. So we did our best to add instructions, requirements, mandates into the policy that we could hold them accountable for, but that were not technically required by the law. And the idea was to encompass those things, that lawful but awful band that so many people talk about, trying to get them up to a higher standard of care. The policy itself is divided into several sections. You have, it's all in Title 8, it's all on the website. And 8.000 has the use of force core principles. This is where the department attempts to set out its values around use of force, when it should be used, under what circumstances, what should the mindset be around that. And it does have the core belief that force needs to be objectively reasonable, necessary, and proportional. And nationally, that sort of triad of ideas, if you were to put them into a Venn diagram, there would be a lot of overlap between them, but they're each trying to give guidance into the use of force that's slightly different. The constitutional standard, and this was the old SPD policy, just required force to be objectively reasonable under the totality of the circumstances. It was the Graham standard. State law required use of force to be necessary, but that was not incorporated into policy specifically prior to 2014. And the proportionality was a new concept in there, because you can have something that's objectively reasonable and necessary, but it still might, in a technical sense, be disproportionate to the threat faced by the officer. It could still be within that, range of reasonable, and using force was necessary, but using that particular force may not have been what the department would have wanted under those circumstances. So it gave it elevated the requirements of use of force as we developed that policy. Also within the core principles is the idea of the sanctity of life and mandatory de-escalation when safe and time and circumstances permit. There are many departments out there that have policies around de-escalation that suggest that you use it, that advise. Seattle has a mandatory de-escalation policy built into the core principles and in its own policy under 8100, a subsection of the use of force policy. 8.050 really just gives the use of force definitions. This gives us the common language to understand what it is we're talking about when we throw out a concept, an idea. And again, that's all available on the website. 8200 is actually using force. This is the guidance to officers on when they can use force. And again, this goes back to the objectively reasonable, necessary, and proportional requirement to effectively bring an incident or person under control while protecting the life and safety of all persons. That's sort of the core issue. Then there is a whole bunch of prohibited force. For example, neck holds or kneeling on neck is prohibited under our policy. It specifically tells officers they cannot use force to punish or retaliate. It says that officers will not use force on restrained persons except where reasonable, necessary, proportional to protect an officer, the subject, or the member of the public from physical injury. So there's a heightened scrutiny on any force that is used on a person that is in handcuffs or otherwise restrained. The policy said officers will not use force against individuals who only verbally confront them. This is the contempt of cop style case where someone may say something to incite or antagonize an officer, and our policy requires them to not rise to the bait and to not use force, unless, of course, there's some physical interaction that goes along with the verbal confrontation. And then a very specific prohibition is on using force to stop a subject from swallowing a substance that is already in their mouth. And there was a series of cases back in the 2000s and early 2010s where you'd have an officer that would use what was essentially a chokehold to prevent someone from swallowing drugs, or and at the time the department, the intent was to stop them from swallowing it for their own good, because you don't want people ingesting that quantity of drugs if they're trying to swallow it. But the choking was not an appropriate response. So currently the goal is to take someone and get them into medical treatment if they swallow that. The next section, 8300, the use of force, weapons, and tools, is to give officers specific guidance on the use of weapons and tools in the use of force. So this would include patrol canine, taser, impact weapons, pepper spray or OC spray, vehicle-related force tactics, specialty unit weaponry. This would be stuff used by SWAT or other specialty units. Hobble restraint, which is essentially a strap that goes around the legs to keep people from kicking. While not technically a use of force, it is included in this policy to give guidance on when that's appropriate. Blast balls, 40 millimeter less lethal launchers, pepper ball launchers, and then spike strips or other tire deflationary device, which is a vehicle tactic. Mr. Waldrop already went through the levels of force. But what's really important from our perspective about the different levels of force, which are de minimis, type 1, type 2, and type 3, with type 1 being, or de minimis being the lowest, but type 1 being the lowest type of reportable force, and type 3 being the highest, is that we really try to focus our efforts on reporting and reviewing force based on the level of the severity. Now, this does not mean that there cannot be excessive force at type 1 or type 2. It just means that we devote greater resources to the review of type 3 and the investigation of the use of force itself. So the way the reporting works is that type 1 and type 2 are both documented by officers after a use of force occurs and is reviewed and investigated at the sergeant level. Type 1, which predominantly is transitory pain or pointing of a firearm or a complaint of pain during the application of handcuffs, is not subject to a large investigation. The sergeant will check the cuffs, they'll make sure there's no injury, they will interview the subject, make sure that there was no intentional pain caused or anything that would take a type 1 and make it something other, either misconduct or a higher level of force. But it is a pretty, I don't want to say cursory, but it is an efficient review of the use of force to determine that it was within policy. And if there are no concerns with it, it is documented, it is put into Blue Team, an IA Pro, which is our reporting software, and it is tracked at the department level. Type 2, there's a greater investigation by still with the sergeant that reports to the scene. The sergeant will interview the officer, will interview witnesses, will canvass the area for video, look for evidence, and will take witness statements from other officers that were on scene. And this is for physical injury greater than transitory pain. This is when less lethal tools are used. This is the primary type of force that gets the type of force investigation that applies to the use of less lethal. So that's done by the sergeant. It then goes up the chain of command all the way to the bureau chief for approval. Again, if at any point any sort of misconduct is determined or suspected, it can be referred over to the Office of Police Accountability for greater investigation. Both type 1 and type 2 are reviewed by our force review unit, which looks at every use of force. And the force review unit, particular with the type 2s, will refer certain types of type 2 cases to the force review board for comprehensive review by the force review board. And that would include anything that has a serious policy violation. If FIT were contacted for a type 3 screening and just declined to respond or investigate, when less lethal weapons were used on the subject, when a canine makes physical contact with the subject, and then crowd management events and major incidents, all of those are referred on to the force review board for a more comprehensive review. In type 1 and type 2, officers are writing up statements. When you get to a type 3, where there's great bodily harm, substantial bodily harm, deadly force is used, if there's any suspicion of criminal conduct by officers or serious policy violations, at this point, it's either referred to OPA for the investigation when there's a policy violation or potential criminal conduct. But if it's being investigated at the department level, the force investigation team rolls out, and that usually involves CSI, gathering crime scene investigation. Again, all evidence such as video, witness statements, witnesses, all of that is gathered. But then in these cases, the officer actually submits to an interview by fit detectives rather than writing up a statement. And the officer is prohibited prior to giving that statement from watching any video evidence in the case. The detectives that are doing the interview may introduce video evidence during that investigation in order to tease out any inconsistencies and test the officer's memory. Those interviews typically happen by end of shift. So the officer is segregated at the scene, is not allowed to watch the video, and then is interviewed using these cognitive interviews. All type 3s go before the Force Review Board for comprehensive review. Again, at the Force Review Board, you have representatives of the OIG and OPA present, as well as members of the department going through the checklist, analyzing not just whether the force was in and out of policy, but looking into the de-escalation, into the supervision, how the scene was managed, whether there were any equipment issues, tactics, training, policy, and department best practices to have, again, a more holistic review of the use of force. And it is overall the department's goal in the analysis of use of force to become a learning agency, to be able to learn from the good, the bad, the errors, learn from our mistakes. And that goes back into a loop whereby the board recommendations are sent out to the relevant bureau and tracked for the recommendations, which can be either adopted, put into a queue if they have some form of financial impact, or if there are other barriers to implementing immediately, or declined. And if they're declined in IA Pro, again, where this is tracked, the declining bureau will state its reasons for that. And it goes back to the board. And if those reasons are insufficient, the professional standards will likely escalate that to the chief for specific review if there's any concern that the reason given was not good enough. And that's sort of the overall of how this functions in practice. So everything that Matt talked about, this is how it was taken in policy and adapted for implementation in the police department. And as I said earlier, all of this is trained regularly. The entire policy is reviewed. This is part of the consent decree, but there's an ongoing commitment by the department to look at its policy annually, just to, again, take any lessons learned and incorporate them into the policy. I think I'll stop there, and I see we have a whole host of questions, but I'll turn it back over to the CPC to guide the next process.
Thank you, Brian. I appreciate your input there. At this time, we are going to someone from CPC. I'm not sure. I can't see the chat, but someone will just read out some of the questions. So just for you and Matt to be able to respond to or take in, acknowledge.
My understanding is that the the Director Grant is going to read the questions or comments out to the panelists. Is that correct, Director Grant?
Sorry, Reverend Walden, it is not. I'm waiting on the facilitator to read the questions out.
Oh, okay.
Sorry about that. Yeah, sorry for that confusion.
Okay. Well, then I'm not the facilitator, so
I understand.
okay.
Yeah. We're just waiting on Felicia to pull, they're up and pull them up. I'm doing some responding, but we're actually going to have her read them out as the facilitator.
Okay.
Yeah.
Thank you.
Okay, I was not prepared for that, so I will just start from the top of the chat as I see it and read the questions down. Let's see. Okay. Of course, Dr. Gale says, how is shutting the community out from discussion and transparency? But let's see, I have Castell Highwater says, as a family member of someone killed by SPD with zero accountability, I second Howard's concerns. Without community participation, how is there transparency? I don't know if anyone want to speak to that. Okay. Okay. It's hard for me
Just a
to.
moment. Someone from one of the presenters should have something to say. I mean, to the community. I mean, about what they're having to say. Otherwise, then the community is going to leave here not having anyone to say something back to them. I mean, we are hosting the meeting, but this is not our meeting. Okay, this is the CPC. We're hosting this meeting so the community could hear from the DOJ the findings that they came for when they came to the Seattle, the findings that brought them here, and the work that is going on and what is going on. But we're not answering the questions tonight. I mean, this is not. I mean, and so any of the questions are directed or to the panelists, and if they can't answer them tonight, you did put your email up there, but. So I just wanted to be clear for the community. We're hosting the meeting, and in the panelists, the questions should be directed to the panelists and not to the Community Police Commission tonight. Thank you.
And thank you, Reverend Walden. I can't see the questions because I've got like a minimal Zoom. So if you could repeat that, I'm trying to write them down as we go. It's my apologies. I'll try to address where I can, Felicia. I'm sorry about that.
All right.
Okay.
Can I feel like I'm being asked to respond to the question about the format of this presentation, which is what I read that question being asked about, is how is the format here not allowing for community conversation? That is not something that I can really address, as I'm not in control of this format. I mean, I will say I do find it it is awkward because I feel like I'm talking out into the ether here and doing my best, but I can't see the reactions of community members. And I understand the reason why this format was set up, of course, because of the security breaches that happened last time that I think were horrific for everyone. So I understand this is a new attempt, but I believe these questions are actually directed at the CPC, and I believe that Director Grant addressed them at the beginning.
That is correct, Brian. And so I'd like for us to move through some of the really poignant questions that are in there from multiple community members that you all would be able to address. And as he said, I already addressed that at the top of the meeting about the format, but there are substantial questions and statements from multiple community members that would be directed specifically to SPD and DOJ.
Okay, great. Yeah, I'm Jeff Murray is here from the department as well, so we'll do the best to answer where we can. And again, apologies for not being able to see the questions. I'm using a web version of Zoom. So I'm sorry.
Yeah, I had not been tracking the questions during the meeting, so I'm just trying to go through them as quickly as I can at this point too, because I was multitasking on the backside. So forgive me if I'm trying to read through them as well before I read them out loud. There's another question about the format. Let's see, community federal.
And I guess I'll say just quickly to format, this was meant to be an informational session sort of about the concepts of use of force, and to Brian's point, sort of how those concepts have applied to SPD's policy. But as I mentioned in my presentation, and as the CPC has mentioned at the top of this meeting, there is a forthcoming assessment during phase 3 on use of force that will be presented before that meeting to the community. And that's where we will sort of have hopefully a more robust discussion about what those findings are from that period from phase 2 to phase 3 and where we are on use of force. So this was meant to be more, informational, kind of provide concepts about use of force and how they work in SPD's policy before that assessment, that phase 3 assessment is presented to the community for discussion.
Thank you for that, Matt. And you're totally correct. The next meeting, the April 12th meeting will be a meeting where Dr. Oftelli will give the presentation on the assessment of everything that was talked about tonight. We just wanted to give some context to what we will be discussing, because we knew there would be a lot of questions for use of force. And then he will, and then the meeting will be wide open to the community to ask any other questions you have or suggestions or comments. So bear with us, because we're trying to keep the meeting contained, but at the same time we know how valuable the topics in the conversation is to the community. So let's see, there was a question about sorry.
Hey, Felicia, can I grab one of the questions here, just because
Sure, that'd be wonderful.
Come up
Thank you,
quite
Brian.
frequently here, and I'm just scrolling down. This one reads, and it's from Dr. Gale. If DOJ is concerned about most serious uses of force, why were SPD killings of people in behavioral crisis left out of the crisis contacts data set? And this has come up a lot, and I know that through City Council, through CPC, we've been asked, and through the monitoring team, we were asked to go back and look at the data on our OISs to ensure that our processes were not leaving out any crisis contacts. And the processes that I described earlier, whereby you have the force review unit, you've got the force investigation team that investigates all type 3s, which includes officer involved shootings, and then the force review board. All 3 of those entities have a built-in backstop by which they consider whether the crisis contact card was, and when I say that, that's actually done in Mark 43, our records management system, has been filled out. Now, typically the reason to do a crisis card is to inform future officers or first responders about behaviors that can be anticipated with that particular person. Obviously, when there is a fatality, that goal of preventing or guiding future interactions no longer exists. Instead, there really is a data point to ensure that when we report out on type 3s, that we are capturing those that involved people in crisis. So based on what was brought up here multiple times, brought up by the CPC directly to the department, brought up by the monitoring team and members of City Council, we went back and audited our officer involved shootings. And we have confirmed that in the department's determination about what was a person in crisis, we have contact card or crisis cards in all of those cases. We didn't update any, we simply confirmed that they did exist. So the system has been audited on those. So the data is correct that we have given to the monitoring team and publicly presented.
right, thank you, Brian. I think they're writing some more, getting some more of the questions out so that the next question, the next person can, whoever's writing the questions out for the CPC team should be probably having the next question ready or comment or reading some of the comments. That's not my job. I'm just here as a co-chair. So so that should be coming up in a minute here. I think the discussion got over a little quicker than we were prepared for anyway. So anyway, thank you for that, and we'll continue that. We're waiting on one of the CPC staffs to help with the getting the questions together. I know there's a lot of going on in the chat, a lot of writing.
There is a question from Dr. Gale. He asked about why are we still talking about proportional force when most cities are getting rid of that. And then he also mentions that it has been unquestionably established that the monitor's data analysis is 100% dependent on the SPD, and it's seriously flawed.
You know, as to the former, I don't think most cities are getting away from proportional at all. I think most cities are going towards proportional. It is a requirement in every consent decree that proportionality be part of it. It is part of the PERF standards, and I think it's nationally accepted best practice. And while there is certainly some confusion about what is, you know, the overlap between objectively reasonable, necessary, and proportional, we believe it gives the best guidance on how officers should think about the application of force. As far as the dependency on SPD data, I mean, first of all, I disagree that it's seriously flawed. Monitor can speak to his own methodologies, but you know, we have very robust data systems. We actually, in the data analytics platform, we actually have error correction, where if there's systemic errors, the system generates errors, and then we have processes to prioritize and go through and address those errors. So it's not a self-correcting system, but it self-identifies data errors that we then work to correct. And there is no data system that is absolutely perfect. Ours, you know, given the fact that we are a major city police department, we've reached the point in time where we are able to have peer-reviewed research coming out of our data systems. So I think there are many people that rely on our data. I also, you know, certainly when we're talking about stops and detentions and crisis, there are data points, and of course the department is the entity that is engaging in the activities, so that's where the data will necessarily come from. I don't know what other data sources could be used. That being said, in use of force and in crisis, both the DOJ and the monitoring team, and of course SPD, are looking at the cases qualitatively too, and actually reading the incidents and coming to determinations. Those statistics you saw earlier about the percent of cases that were found to be objectively reasonable, necessary, and proportional, that is not relying on the department's assessment of that. That is a behind the scenes assessment by the monitoring team about that data. So I disagree that the data is inadequate, and I don't know what other data anyone trying to analyze the activities of a department should rely on other than the reported activity of the department, if you're trying to do it quantitatively.
I'll just echo Mr. Maxey's point, speaking to SPD's data, but the fact that in phase 1 and in phase 2 and in phase 3, there is that sort of look behind at individual cases and not just relying on the data to carry the day there. There is a look behind on individual incidents and to see whether that what we talked about, the reporting, the investigation, and the review is present for the types of force where it needs to be.
There seems to be there's several questions or comments or mentions from Castile Hightower, who has had personal impact, family member being killed, and she, I say she, I hope there it says there aren't even any impacted family members on these committees or loved ones who were snatched from us, not to mention the many who have been brutalized. We could at least be given that respect. So if you're interested in being working more with the commission, you're more than welcome to. We can follow up with you on that if you know from this platform. Let's see.
So I
Uh,
also,
mhm.
I'm sorry, Felicia, may I speak to that one also?
Yeah,
Because
sure.
I think it's an important point, and I will say that there are, as I sit here, I'm not sure when Castile Towers loss happened. Obviously, the department completely agrees that any loss of life is tragic, even if so-called justified. And I'm not speaking to that particular case because I don't know the facts and circumstances as I sit here. I do know there are processes behind the scene that we have been working on, and as part of the consent decree, and also more as part of the city's accountability system, by which the Office of Police Accountability has outreach that it can do to family members to provide support in going through, which is obviously a horrible process to lose a family member and then have all of the scrutiny and public reviews and all of that occur. So there are city resources that can provide support in the event of an officer involved shooting. There's also, the recently modified inquest process provides family an outlet, a direct avenue to explore and test the accountability around the case and the policies and what the officers did or should have done. So while we do not have family representation on the Force Review Board, there are other systems designed to support the family that we are engaging in, and we certainly make referrals to OPA in the current context to support family members. I hope that helps answer the question.
Mr. Maxey, one thing, I'll just have another comment here, and then I'm not going to have another comment. But I think what happens here, and I'm glad for you all to be here with this panel and presentation, is that police accountability in the community's eyes and police accountability, what we're getting under consent decree is like two ships passing in the night. I mean, so you have the families on the other side who absolutely thought that the shootings would go down and that we would have officers maybe charged for a crime. And then we have why the DOJ came to town. Nice presentation from from Matt. I'm not calling your last name correctly, so I'll just call you by your first name. Excuse me for that tonight. And so that is the conflict. I mean, and it looks like we who was over here on the other side haven't done anything, but we worked in alignment of the consent decree and why it came to Seattle. But what the community is looking for cannot be answered under the consent decree because it's not structured for that. So we who worked for this in 2013 and 2010, 11 and 12, 13, we thought we were going to get something differently, and on the end we might. But all I'm saying is that when the community are asking the questions about the shootings, and we go back to the policy and all of the other things that we're talking about, then that's where the disconnect is. And so I don't know, we can't fix that tonight, but I think it has to be acknowledged that that's what the disconnect is when we talk about police accountability. And when people, we're talking about it in one way, and then when you and the DOJ and the monitor and the sustainment and the consent decree, we're talking about constitutional issues, and it does not overlap with individual police shootings. And I think that's what we're hearing in the in the comments. I mean, from affected families and from other people who've been watching this from afar. And I hope I'm making sense. I mean, since I'm sort of like the institutional knowledge keeper of the history, I mean, so that's what the disconnect is. And it's not like the community people all the time are being rude. They're hurt and they're suffering. And they thought that we would be able to get another type of outcome. And that's what we're here trying to figure out. So thank you for the grace of being able to say that. Thank you.
And Reverend Walden, oh, sorry.
Go ahead. No, go right ahead.
Reverend Walden, I appreciate that, and I think that's an apt description of the tension between these individual incidents that we talk about at these meetings and that we talk about in the community, and the systematic approach that's undertaken under the consent decree. And all I can say is that I have heard your comments on that repeatedly, and I have taken them back to the folks here at the department, and we do appreciate what you're describing and that tension between those individual incidents, that Castile was talking about, that you've talked about so eloquently, and then sort of the systematic approach that the department takes in these pattern and practice cases. And we do recognize that tension. So I don't want you to think that ever falls on deaf ears or that we're not understanding that. And so that's kind of the only comment I had on it, but I guess want you to know that I do hear what you're saying, and I do understand it.
Matt, there was a question about whether or not you can give us the PowerPoint to send out.
Yeah, let me, I'll email that to you, Felicia, right now, if that's okay. And then you can, yeah, okay, I'll do that right now. Yep, no problem.
Okay. And then also there was a question about not having the use of force assessment yet. We were supposed to have it 2 weeks before this meeting. Brandy addressed that we haven't gotten it as well. And so as soon as we get it, we will send it out to the community. It said, Valerie says, thank you, Castile Hightower, for your question about impacted families. I think about that at the beginning of the meeting, as impacted families are left out of the people that CPC represents, I think people from the disabled community were left out too. This group has not included people with mental health issues. This is not a question, just a comment. Okay. And please know, Valerie, that we are working on all of those aspects. And if you have any connections or like to shed, then we would really appreciate an email with your input and assistance. I saw another comment, Angela. Angela says, how closely is it that the use of force policy team working with King County Behavioral Health to rewrite policy in handling behavioral response calls? I don't know who, Matt or Brian.
So I think I understand the question, Felicia. So as part of the consent decree, the department created a crisis intervention committee with the Department of Justice and with local resources. And the idea was to bring together everyone that works in the crisis space, whether it's service providers, mental health providers, academics, researchers in that area, educators, the department and other city resources to come to the table, and I think it's on a quarterly basis, to look at how the systems are working, get a better resource map of, where what beds it might exist or what opportunities to have different resources provided to people. And our crisis response unit works to take that information and build that into our crisis response system so that we have a more up-to-date understanding of what options there are. A lot of those options have been very curtailed during COVID, and it's been, certainly a complicated time for actually providing the services. But we're doing our best to route it, and in doing that with the Crisis Intervention Committee, we are drawing on local providers to try to better understand not only what resources are available, but how our systems are working and how they can be improved. So when we come out with a crisis intervention policy, that gets vetted by the CIC as well as the monitoring team in DOJ to try to get that, more local perspective in there.
Matt and Brian, just so we're making sure that we're giving folks the opportunity to ask their own questions and making sure that they're really clear. There's been a lot of commentary in the chat about being able to have an actual dialogue with you all. So we're gonna work to get folks to re-raise their hands so they can ask any questions that have not been pointed out already to the both of you, okay?
We'll follow your lead.
Dr. Gill, you should be able to unmute yourself.
Yeah, I think I am. I won't, there's a whole list of questions we haven't gone over, but Mr. Maxey, I again will challenge you. I have gone through the SBD publicly available data set 4 times. I've captured snapshots and downloaded it. So I don't know if it's been changed in the last few days, but certainly as of 2-3 weeks ago, the 6.5-year period covered for the crisis context is missing the 9 people in behavioral crisis that were killed by the SBD. That is just simply a fact. If we're talking past each other and you're talking about a different data set, then that should be made clear. But I'm going to repeat it again. The data set available right now does not have those people who were murdered.
I hear you. That's not my understanding, but I will have that re-audited and double check it.
And actually, if I could just, this isn't complex. I just put the names in the chat. And let me tell you my procedure. It wasn't, this didn't require Sherlock Holmes. What I looked for was any use of force, any type 3 use of force, either on the day of or even as late as the day after, that would correspond with a death. That would correspond with any of the demographic information, male, female, and it's simply absent and missing. And I even allowed for the fact that maybe it happened late at night, maybe the report got rolled over, it was a day late, whatever. And in all 9 of those cases, I put them in the chat, and I will say 8 of those are unquestionably severe behavioral crisis. I mean, it doesn't take a complex definition. They were almost all 911 calls where someone said someone was acting crazy. In one of the cases, I would grant that there's some question. I think it was a behavioral crisis, but anyway, I think I made the point. The 9 names are in there. I sent them to Ofteli on January 24th, and there has still been no response. So.
Hey, Brian, this is Jeff from DOJ in Washington. There's another question related to this issue that raises an interesting point. It's from Diane Ramsey at 10:03 p.m. She asks, since the community believes some of the data is flawed, inadequate, or missing, has SPD OPC considered hosting a work session to specifically address the data issues? And I'm wondering if that's an idea that SPD would consider, even if it's something like this informational session, to sort of, out some of the specific questions and see if they are, existing in the data as they're reflected or not, to see if some of this tension about, communication and information sharing and transparency can be resolved. Did that idea have any legs?
I'd have to think about the format of it, but I think that we certainly have some work to do to get a little more confidence about our data. There are certainly some complexities to the public facing data in that the city has privacy rules about what we can release when we're talking about use of force, and it becomes personally identifiable. That becomes a breach of the city's privacy standards. Same thing with people in crisis, so that we actually handle those data sets slightly differently. So matching it up one-to-one can be complex. The rules are posted along with the data sets to give greater transparency, but clearly we have some more work to do here. I know that our researchers have been engaging with the CPC, with Evan Lee on better understanding the data, because this is obviously a concern for the community. I will absolutely say the data is not perfect, but it is some of the best in the country. And I do stand by that. So yes, let's figure out a way where we can come together and, within the limits of privacy and city standards, help correct and or clarify as appropriate.
Thanks. I didn't mean to put, throw you under the bus or anything, but it seemed like, a question with a positive solution staring us in the face. And I figured it was worth raising.
The department's either transparent or it isn't. So, we'll figure out a way to engage on this to help build a little more legitimacy here.
Castile, I'm going to bring you in so you can speak. I see your hand is raised.
Yes, can you hear me?
Yes.
Yeah, I'm sorry. It might be a little off subject, but I feel disrespected. This is absolutely having to do with people impacted by the police, whether that be by murder, killings, or harm. This is not something that is passing each other. This is not something where we need to be pitting the disabled community, who also people who have mental health issues can be considered disabled, who have been killed and murdered by the police. This absolutely is an issue that has to do with impacted folks and impacted families. We should absolutely have a voice in this. And I absolutely feel 100% disrespected, as anyone in my position would, to be told something like that when I'm coming to a meeting that's supposed to be talking about accountability and the consent decree because of the abuses that we have suffered under by the Seattle Police Department. So please, if you are going to address us, if you're going to address us as a community, please have a little bit more respect in regards to that, and don't dismiss us based on your own experiences that you do not share with me. So whomever has that attitude, please show a little more respect to impacted families and impacted family members, because we should be having a voice on this. We should be on this committee. Absolutely. Because if anybody's impacted, it's people who are 6 feet, 9 feet under the ground right now, who don't have loved ones, who can't see tomorrow. Absolutely. Please try to pit that against you being able to get up every single day and breathe every day. I'm done.
Ms. Castile, I wanted to just let you know, Ms. Hightower, wanted to let you know that we understand and I recognize your grief and it's ongoing, and I understand that. I too have lost a son, but not to the police, but I understand that. And so we want to acknowledge that. And we want to acknowledge the fact that this forum here tonight was about the DOJ bringing information to why they came to town and the consent decree and all that stuff. And so you're correct that this probably was not the correct forum for affected families, but this was just to bring information about what is happening along the consent decree over these last years. And so you're so correct in what you had to say about your feelings and that. So just want to let you know that as one of the persons on the Community Police Commission and a parent, I want to acknowledge you and in your ongoing grief, and I want to give you my condolence.
Valerie, I'm going to unmute you so you can speak. Give me 1 sec.
Okay, can you all hear me?
Yes.
Yeah. I just want to say very briefly that I totally agree with Castile Hightower that there isn't, if we're really doing the right thing, there can't be any division between what a member of an impacted family who's really experienced extreme loss at the hands of SPD brings to public meetings and a discussion of policy. If there's a big division like that, then we're not having the right conversations because we're not really talking about reality. And this is yet another one of these meetings that's set up as if we can just talk about abstractions and abstract policy without talking about the, real people, as Castile says, real people have been killed, real people have been terribly injured. And it's not negligible. It's not a negligible number of people. No one person is negligible, but actually it's a lot of people and it keeps happening. So let's just reframe our entire conversations and our whole area of action here based on lived experience and reality and humanity, not the abstractions of policy, because the policy is meaningless when we're getting the outcomes that we're getting. That's all.
I see Queenie, so I am going to unmute you. Hold on one sec. Okay, you should be good to go.
Hello. I've been to a couple of meetings, and I was informed that it's a strange word to see data. These are human beings, and I used to be a human being, I guess. Now it's not being human, but I've been affected like the full circle. My cousin was killed by the San Diego police. I have 5 friends that was killed by the SPD. Then I go and educate myself, the person that is against me, and educate myself with the police academy, the community academy, to learn what are they doing. And then I hear the mediator saying data and levels, 1, 2, 3s. It affected me hard because I know the person they're calling. I have a friend that gets those calls when somebody is upset or outraged or not doing well. But I don't know what kind of program, because I don't think he's in my county, but I want to understand the steps that the county takes when the police come in and somebody's being outraged. What are the steps they take? Those like, oh, there's 1, 2, and 3 in pain. I don't get the pain because I still, Miss Ely, I still live with her son dying, being pulled out of an ambulance and being choked to death. And I fight for advocacy for any and everything, but this affects me because I have a young Black male that I'm going to always advocate for and the people and my community. But when I hear not like formats or anything that says, this is what we do, this is how we do it, and they have committees that come quarterly. How is it that we have committees that get together quarterly when we still haven't got a format put together, when they should be meeting monthly and getting something done and saying, hey, let's take these steps? Can somebody please explain something? That's it.
Queen, there was a lot in that statement, and I'm probably not going to be able to do justice to it at all. I certainly hear the frustration and emotion behind it. With regard to the Crisis Intervention Committee and bringing people together, because we are tapping into a lot of resources and a lot of community groups and asking them to come together and give their time, it was not practical to do it monthly. We did it monthly for a while we were developing the crisis intervention policy. But since then, it has gone to a quarterly meeting out of trying to respect people's time around that. the groups that we're reaching out to are, they're community groups, they're educational institutions, University of Washington professors and clinicians, the City of Seattle's disability rights, all of these groups that we're pulling together. It really just became a time resource. So I'm sorry if that doesn't do justice to your question, but thank you.
Dr. Gale, I saw you raised your hand again. Did you want to speak?
Sure, I'll remember to lower it before speaking. Yeah, I just want to get back to, again, there's a lot of questions that are going to go unanswered, I get it, but I want to focus on one thing, and that is, I put in the chat, I don't know of a profession. I'm a psychologist. I've worked in hospitals my whole life. I don't know of any profession where policy can be divorced from accountability. That is, why would people adhere to policy if there's no consequence? And this isn't just Seattle. This has been the problem for 150, 170 years with policing, is there's always a divorcing of policy from accountability. So what did we see in 2020? We saw literally hundreds of people, many dozens of whom are suffering severe brain injuries because of police abuse. And the greatest degree of discipline we saw was, I think, 5 days. I think there was one officer with 5 days, a couple with 2 days. And the vast majority of cases that were found to be valid were officers that were simply given a reprimand. And in the case of recent shootings of people in mental health crisis, we found the last two, that was Terry Caver in 2020 and Derek Hayden in 2021. In those killings, it was found that the officer egregiously not only failed to de-escalate, but actually escalated the situation. And yet when it came to shooting the person and killing them, there was no fault found and no criminal charges. So I think this is the problem that I have, and I think most people have, is that we can write policy and we can speak about it in wonderful phrases and terms, but it does sound like a fairy tale. Without accountability, there never will be policy that's actually followed. That's it.
Agnes, I see you have your hand up, so I am going to unmute you now. You should be good to go.
Okay, I'm perplexed about a lot of things, but first I want to thank the people who've participated, Castile and Queenie, who have been so impacted, and the courage and the ongoing trauma that these meetings put forth for you. I come as a community member who was expected that the CPC offered this as a venue, and that this was really the court-appointed federal monitors meeting. And I feel it's been a very confusing evening. And I feel that the gentleman from the DOJ gave us a nice PowerPoint, very quick, on everything the consent decree has to say about use of force. And then the gentleman from SPT gave us a long treatise on statistics. And I don't question any of your good motives or intent, but I'm reminded about how you can present a lot of data, you can say a lot of things, but no real information really gets imparted. And I think that's what I hear when people start talking about, these are people that you're talking about. And when Reverend Walden talks about ships missing in the night, I just feel like the court-appointed federal monitor and the community are simply missing in the night here, are just not not communicating. And I really do hold that court-appointed monitor responsible for that. I don't hold the CPC responsible. They're providing this venue. But to have us all talk with no visual and disembodied for, much of the meeting, just reading things in the chat. This is really, as a community member coming to this, expecting to have the same kind of dialogue that we've had in past meetings. This has been extremely disappointing. I understand that we're going to have a meeting in April. I just don't understand why Dr. Aftali didn't present. He promised last month that he would submit his report and we'd all get to read it and be able to discuss it tonight. And instead, we're given 2 presentations, which, is fine. I'm sure they'll all be repeated in the assessment that will be sent to read. But I'm sad about the kind of energy and time that went into this meeting. And I wonder to what, does it really bring us to what I believe is a shared intent on truly just and accountable policing? And, how do we move ourselves closer to that? And I do not believe that this meeting moved us closer to the goal of more just and accountable policing in Seattle.
Thank you for that, Agnes. I just wanted to see, I don't see any other raised hands unless Queenie, you'd like to speak again, but I just wanted to offer space to anyone else who'd like to speak. Carol, I am going to unmute you now.
Okay, hi, I'm a member of the community and sometime I have to, speak to other community members because members of my community aren't coming to these meetings. And so I am trying to learn about the DOJ's job and the job of the federal monitor. And I'm trying to understand the data that's presented. And I certainly get the point that SPD and the people who are presenting here understand their jobs very well. You understand that very well. I don't know what it's like to have people who can't go as fast as you because we just aren't familiar with this information. I don't know what that's like for you, but it would also be great to hear from families, and somehow I would really hope that you can connect the two, your job and how you will get through this consent decree with the police department. And it would really help for a person like me to somehow connect it to some of those feelings these family members have. Thank you.
Brian, I see your hand is raised, and just before I move to you, I want to see if anyone else in the community has anything to say. Okay, Brian, I think it's all you then.
So I'm going to put myself out here a little bit and probably get myself in trouble, but I feel that some of the disconnect between the community expectations around the consent decree and what that is and what its intent was and what the community wants to see in policing overall are not the same thing. The consent decree is an agreement, it is finite, and it asks the police department and the city to create policies, to train to those policies, and then to submit to assessments to ensure that it is following those policies. And those assessments are both, quantitative, counting the numbers, all the statistics that you've been presented. And it's also qualitative, which is reading the cases along the way. and making, the monitor makes qualitative assessments and the DOJ does the same thing. That structure is depersonalized. It is about systems that are necessary. I mean, policing impacts people, there's no doubt. And those are real people that we're talking about that are behind those statistics. But the consent decree really isn't set up to grapple with those issues on a personal level, which is what I'm hearing people in this group talking about, which I think is absolutely valid. And in my mind, the next phase really is whether we in Seattle have created accountability systems that can continue to carry this work at evolving public safety and thinking this through. But I guess in my mind, the disconnect is thinking that the consent decree itself is necessarily the vehicle for that. And I was involved in the consent decree at the very beginning, and I've come back to the department and we're grappling with these same issues. And even as we're having many of the same conversations, when I look at what has been done, and probably why we focus so much on data and information, is that we finally have it. We finally have an understanding of what officers are doing on a day-to-day basis, when they're making stops, when they engage with people in crisis, when they're using force, and they're writing it down. And all of our systems are doing the best they can to digest that and understand it. But I fully understand, amidst, data and review and analysis and lawsuits and inquests and processes, that the very real personal impacts are lost in the complexity of the system. And I guess I just don't feel that the consent decree is fully designed to address that. And I think it falls to this group, to our community, to the department, and all of our accountability structures to carry that work forward.
Thank you, Brian.
Yeah, thank you, Brian.
Dr. Gale, I see your hand. I also see Diane, and Diane hasn't spoken yet, so I'm going to let her speak, but I will come back to you.
Thank you. Thank you, Mr. Maxey. And I've only attended a few of these meetings, but my observation has been exactly what you just spoke of. And the piece that I believe is missing is that piece in the middle. I'm not sure that SPD, the union, OPA, I'm not sure that anybody has really come to the community and had a serious, honest conversation about what is it they are expecting to see. And once you get that information, you have the data, you're collecting it on your side. So there's that piece in the middle that somehow you need to bridge that gap. One is the data issue that keeps coming up over and over. And I think that's pretty easy to solve. I know you talked about there are certain things you couldn't disclose, but there are certain things you can. The numbers, making sure the numbers match, even if you say we can't, divulge the name or the condition of the person, but you make the numbers match, and at least you've eliminated that as an issue for people to have problems with. So I think you totally understand what's missing, but I think you and the city and the union and whoever else, DOJ, whoever else is in this, the community need to just have an honest conversation and get a list of what they want to see, and then go back to your data and say, how can we provide that? So my 2 cents. Thank you.
Okay, Dr. Gale, the floor is yours if you'd like to speak.
Sure, thank you. Boy, Mr. Maxey, respectfully, I think you did identify something correctly, that there is sort of a gap between data and what people experience in their real lives. I'm a psychologist. I'm not a clinical psychologist. I'm a research psychologist my whole life. So I know what the gulf is sometimes between data and real life. The problem here is there's actually a problem with the data, in addition to bridging that gap between the data and real life. And I've gone through some of this in earlier sessions, but I'll just throw out a couple of things. In the crisis contact data, 40% of the crisis contacts have no listed outcome. That is just bizarre. That actually is in the public-facing data set, and that is in the monitor's latest report. So I think there are a lot of problems with the data. The use of force data set, it's been promoted over the last 5 years as being very transparent. It's not transparent. You can't click on it and look at a go report or look at a use of force report. I could also go into incredible detail that's going to bore people, but it's absolutely critical. Use of force reports, a lot of people don't know what that is, but it is a separate report from a go report or any other report. It's when an officer does use any use of force. Those reports have no audit trails. So when an officer writes how and why he used force, it goes through a series of sergeants and lieutenants who kick it back to the officer and say, look at this, look at that, correct this, correct that. And there is no audit trail. So we don't know how much of these use of force reports are actually sort of jerry-rigged, as I said, to fit policy. And in fact, I do have evidence that that has happened. So that's one thing. The other issue is I keep on coming back to policy without accountability makes no sense. Mr. Max, you're absolutely right. The purpose of the DOJ and the consent decree is to establish a floor, a constitutional floor. But there's no reason why we are settling for that. Is beyond me. Why the CPC, for example, again, I won't go on much longer, but in 2017, when the CPC and the council, Lorena Gonzalez, went to look at other models for police accountability and police oversight, they went to New York City, they went to Los Angeles, which simply do not scale with Seattle. And they're actually horrible police accountability systems. I think Los Angeles, between the sheriff's department and the police, has been under consent decrees, 8 times now? So they went to visit those cities, but they failed to visit Newark, which had a much more community-based citizen oversight board. And that was actually intentionally done. It wasn't simply an oopsie. It was considered too radical for Seattle to continue. Since that time, that's 2017, Newark has adopted a much more radical police oversight system that is working. Oakland is in process, Portland, I could go on and on. My point is, we're settling for something we should never have settled for, which is constitutional policing. Under constitutional policing, we can still be abused. So again, that's why at Seattle Stop, what we're requesting is that we really engage in a citizen initiative where we can take back control of our policing, which is what happened in Oakland, in Portland, and in Nashville. Thanks.
Thank you, Dr. Gale, again. I was told by Director Grant, Queenie, that you'd like to speak again, and I'd like to make space for that.
Yes. Can you hear me?
Yeah.
Okay. Well, I do security for gay bars in the neighborhood, and I've been educated by SPD, not life, educated by Homeland Security, educated by active shooters because of the place and where I work. And just like dealing with people, I'm feeling like sometimes the police just do not act when people have mental health issues. They act like they're the problem, but they are the ones that got the problem. And even when I deal with those people, and I'm educated by the people that are against me most of the time, I have the strength to say, hey, Even when I'm at my bar, when I'm dealing with them, I deal with them as a human being. And I was just when the monitor kept on saying data, I'm not even in the data. Because half the time, police officers, I got assaulted by the Broadway taxi cab, right? If you remember Broadway back in the days. I got assaulted when I was like 16. And he was just, it didn't happen. Like threw me away. I was stopped because I was driving my El Camino because I like good things. And they was like, well, your tabs. I was like, I got custom tabs that are in the window. And there was 2 police officers looking in my car. I have friends that had been in distress that I was going to be the next victim because I was going to whoop the police officers that was mistreating somebody with a mental health issue, and the brother came to help. This is distressing. I want the union to also come in because I want them to see what their policies are doing to the people that are they're supposed to be protecting. We need to change the whole circle so it makes more sense to have an understanding that we're human beings, we're people, and then I wouldn't give up a precinct. I would have never gave up a precinct. Because I worked up the street and I needed that precinct to help me out when I needed help. So we got to look at this. This is a whole scale of things because we're all getting hurt regardless. Even if you can walk down the street and get hurt, then you don't have a place or a person to even come and get you about an hour or 2 later. Come on, man. We need it all wrapped together. We need the union in here and all the therapists and everybody else working together to help us out. That's all.
Queenie, I have to step in and say thank you. Thank you so much. I'm always calling on you, and not to re-traumatize you and all the things you've gone through. I know I've been right here with you since you were a kid, since we both were kids. But I appreciate you always being able to show up and be vulnerable in whatever space. And please know that it's people like you in our community that need to step forward, and we need to hear these stories, your story. There's so many more. We know there's countless stories out here, but one of the, and we have to be honest and straightforward and say this, one of the things, the reason why we don't show up in the data is that we don't always um, believe in the system enough to file that official report. And that's what they're counting, are those official reports. Because there are some communities who don't have a problem picking up a pen or typing out a letter on a computer the minute something happens. But we're more reluctant to do that because we want the least exposure and the least least contact, especially after we being done over and over again about in these same type of situations. So once again, I thank you. I appreciate you. I do, and you're always there to step up and step forward. But this is the hard part about trying to get this work done. This is the hard part about this work we're doing right here, and we can't do it without participation and involvement from everybody. So, and I know, hey, I know whenever I see you anywhere, you first to talk about your, educating yourself and the knowledge base you have, and still you still feel this way, but you haven't given up the fight, and I appreciate you for that. I'm not patronizing you, I really mean it. So I'm going to encourage and hope and want you to please continue. Don't give up. And I know that the word data had been triggering to you because you and I talked about that. But what you need to understand is just what I just said, that to be counted in that data, we have to start encouraging, educating, and promoting our community members to come forth and be a part of that data. Make that formal complaint to OPA, whether you feel like it's going to go anywhere or not. Do it anyway, because it has to be counted. And and as we know, the squeaky wheel gets the oil. So if we keep at it, things have to get better. But it's never gonna. No one's ever gonna see you. I'm not gonna say see you. No one's ever gonna um come to you and knock on the door and say, can you fill out this form? Can you fill out this complaint? So we got to do it. We have to do it. So don't get discouraged, and please continue to push your community forward, because I know you do that. No, despite what you feel personally, I know you continue to do that. So thank you. Thank you, thank you, thank you. Vicky, is your hand up? I
Yeah.
can't see.
Am I
Okay.
muted? Yeah.
Oh, okay, you're good. Go ahead.
Hi, my heart is broken hearing Queenie and Hightower, and I just can't sit here and not say anything. For those of you that don't know, I chair the African American Community Advisory Council. And one of the reasons why I do it is I want the community to have a platform to use for their voices to be heard. And please reach out to me and let me know whatever I can do to help you out. Queenie, you've been to meetings, and I appreciate how open and honest you always are. But if you guys want a meeting, just to be heard and to share and to come up with solutions on what you need. And and I understand all the way why they had to hold the meeting this way. I took a chance last month, and because it's hard. I want people to speak freely and to be seen. And I'm not saying anything against the CPC, but it is hard and frustrating. I'm having a hard time with this too. And actually, I'm going to try to meet in person. And if anybody reach out and really wants to utilize that platform, I will cancel my guest next week, who is the city attorney, Ann Davison, because I want to put the community first. So maybe I'll put my email in the chat box, and please reach out. Thank you.
Thank you, Vicky. Imaja. Can you unmute yourself? Okay. Wait, let's see.
Yeah, thank you.
Okay, there you go.
Imaja. Yeah.
Imaja. Mm-hmm.
Yeah, I appreciate Queenie sharing your story, because there's so many stories, right? And some of us have the pleasure, and we're blessed to be here to share stories where others, loved ones, community members are not here. They've died at the hands of police abuse. So I don't think it's about not being heard. I think it's about policy not being changed, right? I think that's what I heard in those conversations and in those stories, because there's all kinds of stories. And so, yes, do the data and fill out a survey, yeah. But just like the gentleman had wrote, I believe the gentleman had wrote in here, that's if you believe the system is going to work for you. It's kind of a both and. We have to do everything, but that's not the angle here to go complete the survey. But clearly the data is being weaponized against our community for not doing it, when there's plenty of data that's showing what the force is looking like, the deaths that are being encountered, or what have you. So I just want to speak to that. Like when people speak about the data, that's how white mainstream culture moves, because they don't often, the culture, not individuals, I believe, don't understand it's like person to object. They connect more to the numbers to make things real rather than the experience that people are really living. So if that's the both end that we need to do, okay, that's a strategy. But it doesn't change the fear that for our lives that we are living under every moment, especially when this use of force came back and they didn't even want to put in reasonable force into the law. And it's political season, so I have to think about a lot of those things, like at the expense, what's being moved at the expense of our lives, right? Because I know some people need this to occur, but for our lives. And I didn't, I wasn't happy that officers felt like they were tied and couldn't do anything from the previous law, but there needed to be some balance, because to go back this far to where they can do Terry stops on us and kill us and define what they felt they needed in their minds of it. It just took us all the way backwards. And I was also wanted to say, I think that having that conversation with the AN person next week at the other meeting is still going to be good, because my understanding of their platform was about, more of this policing. And I think it's all great politics, how people are talking about it, to maybe make a particular base of people in our city of Greater Seattle feel more safer, but it totally disregards the reality of those who will be targeted and profiled and literally killed because of it. And so if our leadership is not going to talk about the balance while we're talking about filling out some survey, I don't know. I don't know how that could bring anybody comfort out of this space. So I'm just sharing how I'm feeling. After Charlene allows, I didn't feel comfortable calling the police and people threw a bottle at my kids when they were like elementary age. I didn't feel comfortable calling the police about really basic things. And even myself, having the police come to my door and I need to explain to them and just how I've been treated. It's very it's very life or death in these circumstances, which plenty of people can understand. So I'll stop there. I just don't want to equate our livelihood with data. I just want to, I do understand though, it is a strategy that many of us can use. Thank you.
You know what? Thank you so much for that, because you are right. It puts it all in perspective in how we view this information we're receiving and how we view the information that's been provided to us. I would love to have a conversation about maybe with some our partners here, with our accountability partners, how we can address just what you just were talking about, on this level, from the if community standpoints that don't see it in the data, in the numbers, in the ones, twos, and threes. So I think that's a conversation, and this is the platform to be able to put that out there. But it is a strategy, and I would really love to have a bit broader conversation about that. Let's see, it was somebody. I'm sorry, I forgot. Castile. Castile, we got a couple more minutes, and so we'll wrap it up with you.
Castile, you should be able to speak. Unmute yourself.
Sorry, can you hear me now? Oops, can you hear me now?
Yes, you're good.
Okay, great. So that's what I was trying to expound upon when I was talking about being disrespected earlier. When you have just data, you are missing the faces of the people who have been directly impacted by the police abuses, which led to this consent decree to begin with, was the lack of accountability, the abuses that have continued to happen even thereafter, and the victims who are left with what? With lost loved ones, with trauma, with brutality, with harms done to their bodies, to their minds, to their spirits. We cannot disconnect this from those who have been impacted. We cannot. And I think that speaks to the issue that I was talking about earlier. Why are there no impacted families, no impacted persons on this committee, on this council? Because we see what the result of that is because when an impacted family person like myself comes into a room and say, hey, X, Y, and Z, and gets the pushback that I initially got was, well, there's disabled people, and well, this is just two different issues. And then you have the community push back alongside with what I stated that, hey, no, this is actually important. It's prevalent. It's necessary in order to be able to get something that we all can agree upon, or something that actually can truly impact the community that it's supposed to protect. So I hope that this is a reflection point. I hope that this is something that is genuinely taken in, not just from what I've said, not just from what Dr. Gill said, but just from the cumulative voices that you guys are hearing, saying that we do deserve to have a voice in this. We do deserve to be more than data entry points. We do deserve to have our lived experiences added into the equation of what is going to allow our communities to not only be safe, but feel safe and actually are safe. So, yeah.
I appreciate you. Please don't stop coming. We got to lay the foundation. I know it's draining. Reverend Walden, were you going to wrap it up?
Oh, wow. Gee, well, thank you. This has been very powerful and enlightening and traumatizing for some people that we apologize to. Wow. All I can say is I've been at this table for 32 years. And so the people who come and go, it's been a journey working toward police reform. You take one step forward, and as someone just noted today, that the legislature went back, and so we're grateful that we're still on the road. Next month, the monitor is supposed to be here. He's going to go over all of these. The last presentation that I think he put it in the chat. His report should be out at least 2 weeks. Actually really soon, because March is going by fast anyway. It will go by fast. So we just appreciate your time. I know that we wasn't able to answer all the questions or solve a lot of problems tonight, and that's just how democracy is. Sometimes it works, and it's some work in progress. So we thank you all for coming, and we tried to get to most of the questions tonight. And we have emailed, and I'm sure that Mr. Gale and other people will continue to be around. And we invite Tyrone and other people to come and get involved. I mean, there's seats available on the commission. I mean, so if some people are so inclined to want to become a commissioner, well, then there's seats available. I mean, I think there's the city council has some spots. And also the mayor's office have some spots for people who, so if you're interested in being a commissioner, well, please reach out to the mayor's office or to Lisa Herbal there, to Councilmember Herbal there with the police. I think she does police safety, public safety, and put your name in. That's another way you can get involved. Become a commissioner. We're all volunteers. We're doing the best we can. We're flawed human beings just like everybody else, but we keep going. We're not perfect. We just keep going. So thank you so much for coming, and have a good evening. And we'll see you next time. Thank you. Bye-bye. Thank you.